Honorable Attorney General.
Madam Deputy Speaker, I beg to move that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago and for other related matters be now read a second time. Madam Deputy Speaker, the bill before this House tonight has as its backdrop the declaration of a state of public emergency by Her Excellency the President in July of 2025. At that time, the President, acting on the advice of the government, declared that a state of public emergency existed in Trinidad and Tobago. That advice came as a direct result of intelligence gathered by the Trinidad and Tobago Police Service of an imminent existential threat to the state, to state actors, and to assets of the state. The threat emanated from within the prison walls and, as previously discussed, was a result of collusion and collaboration among gang leaders within the prison system, their affiliates and gang members within the society, to persons who held office and to property in the society at large. The state of emergency was extended twice by this House. It is expected to come to an end in 2 weeks, that is to say, at the end of January 2026. It is the government's position and that of the majority of the population that the state of emergency was effective not just at dismantling that threat, but also at frontally attacking criminal gang organizations and their activities throughout the length and breadth of Trinidad and Tobago. The Trinidad and Tobago Police Service and the Defense Force, along with effective intelligence gathering and utilization by our security services, have significantly reduced the number of murders, robberies, kidnappings, and heinous crimes by some 42% in most categories during the year. On the 31st of December 2025, the Honorable Prime Minister stated as follows. She said, "I promised that my government would act decisively to reduce crime, and we have delivered on that commitment. As indicated," she said then, "by midnight, our national murder rate will be down by 42%, the largest decline in our nation's history, and one of the most significant drops globally this year." She paid tribute to the efforts of the TTPS for their relentless work, discipline, and determination, which she said had been critical in lowering both the murder rate and serious crime across Trinidad and Tobago. She concluded by saying, "Our fight continues. Our country deserves safety. It deserves stability and peace, and we are making it happen." Madam Deputy Speaker, the fight against crime does continue. Strategic operations by the TTPS and Defense Force have provided critical insight to us into the operations, funding, locations, bases, identities, and affiliates of the gangs who have been running amok in this country unchecked for some 10 years. Consequently, law enforcement has been able to virtually pinpoint the operation bases of various gangs and to more fully understand their patterns and movements. It is no secret that many communities across Trinidad and Tobago have been plagued by criminal activity for many years, with gangs headquartered in and operating in hotspots. Gun violence, bloody murders, reprisal killings, extortion, and induction of young men into gangs are the order of the day. Most of us would never even venture into the areas which are known as hotspots. Too many communities in Trinidad and Tobago bear the scars of intergenerational trauma, systemic poverty, and vicious cycles of broken homes and lost children. Those law-abiding citizens who are seeking a better, honest life do so at their own risk and face the stigmas in broader society of coming from this place or that place. But we say, Madam Deputy Speaker, that these are our people. They are our citizens. They are our constituents, and that they have been overlooked for far too long. My colleagues opposite talk glibly about crime plans and the absence of a crime plan. They sat there and did nothing, virtually nothing, for 10 long years, allowing this country to descend into bloodbaths, seeing our grandmothers, our friends, our daughters, our colleagues brutally raped and murdered, and not lifting a finger. We have brought the incidence of violent crime down to their lowest levels in a decade. And we have done so within less than 9 months of taking office. Madam Deputy Speaker, we are not going back. There are many who see everything in this society from a lens of color and race and would predictably attempt to bring that and those matters into this debate. I would like to ask them today to try looking at things from the perspective of what is actually taking place. They speak for themselves. The numbers do not lie. And you know what else cannot lie? The fact that every single digit, every single number, every drop by 1% in these statistics refers to a life. Many lives many human beings, all citizens of this country, mothers, fathers, friends, children, grandparents, people that each and every one of us in this chamber know. Madam Deputy Speaker, there are legislative precedents for what we seek to do tonight. And there is, in this part of the world, a legislative precedent in the Commonwealth Caribbean. The Law Reform Commission would have studied and considered similar legislation, and they fastened on the Jamaica model. The bill is based on the Law Reform Zones of Special Operations Measures Act 2017 of Jamaica. And that piece of legislation has been seen by many as a valid and effective constitutional tool in the fight against crime, especially serious crime. Now, if you look at the premise of the bill that is before the House tonight, it seeks to balance the need for security operations to address serious crimes within defined communities. Now, it balances that concern with the rights of our citizens. It aims to preserve fundamental rights and freedoms of persons residing in those communities. Most significantly, the bill also takes into account the need for social intervention and community development. It contemplates measures which can turn at-risk communities around to preserve public order and to promote the rule of law. Members would have noticed that parts 2, 3, and 4 of the bill provide for enhanced security and enforcement measures. That's achieved by proposing the establishment of zones of special operations in a specified geographic area. Part 5 of the bill proposes a community development aspect. The schedule to the bill establishes the structure of a social transformation committee tasked with treating with the conditions which facilitate the breeding and perpetuation of crime in the affected areas. I wish to make it clear, the bill does not seek to marginalize the citizens of any community in Trinidad and Tobago. That is not and will never be the intention of this government. It is instead a demonstration of our recognition of these communities as deserving of better. The bill is a design solution aimed at cleaning up crime in at-risk communities on the one hand, while addressing their specific socioeconomic problems that have been ignored and allowed to fester under the last administration and for the past decade. The government, through this bill, seeks to bring an end to entrenched cycles of violence sustained by poverty, despair, and poor environmental conditions. Persons in these communities will be given a chance to be a part of the changes we seek to implement by providing opportunities for them to engage with the government, civil society, and members of the community at large. I should like to turn now to a clause-by-clause analysis of the bill. The bill has 28 clauses. Yes, I know. It's late at night.
And we don't want too much questions.
A lot of my colleagues are exhausted.
No. Not on this side. Not on this side.
And I know at least one person on the other side who might be having a particularly difficult night. I don't want him to have a particularly difficult time. I'm trying to get him home to bed at a decent time. Part 1 contains clauses 1 to 5 and provides for preliminary matters in the bill. Part 2, 6 to 9, for the establishment of zones of special operations. 6 empowers the Prime Minister to make an order to declare an area a zone when there are reasonable grounds to believe that A, there is rampant criminality, such as murder, gang warfare, or high or escalating violence, or B, the rule of law and public order is under threat. An order made must clearly define the boundaries of the zone. A zone cannot cover the entire country. For that, there will have to be a state of emergency. The order will state the period for which it will operate. It cannot exceed 180 days in duration. Clause 7 allows the Prime Minister, in council and after consultation with the Commissioner of Police and the Chief of Defence Staff, to amend the boundaries or duration of a zone. The duration of a zone may be extended in increments of up to 180 days. An order made under this section is subject to affirmative resolution of the Parliament. The Parliament has a say. It is similar to the legislation in Jamaica. Not identical, similar to the legislation in Jamaica. Clause 8 requires the Prime Minister or the Minister responsible for national security to present a statement to Parliament within 14 days after a zone is declared. 9 allows the Prime Minister in Council to revoke a zone at any time, either on her own motion or B, based on the recommendation from the Commissioner of Police and his Chief of Defence Staff. Part 3 contains clauses 10 to 13 and provides for the administration of special operations within a zone. Clause 10 provides that the Prime Minister can create a joint command comprising 2 senior officers, 1 each from the police service and the defense force, to be jointly in charge of operations within the zone. The members of the joint force must have specialized training in human rights, use of force, and community development. Clause 11 imposes a duty on the Joint Command to submit a written report to the National Security Council every 30 days while a zone is active. Clause 12 provides the Prime Minister with the power to A, suspend operations within a declared zone on her own motion or on the recommendation of the Commissioner of Police and the Chief of Defence Staff, or change the members of the Joint Command under certain circumstances. The clause ensures that decisions to pause operations are informed by senior security officials with direct operational knowledge, and also provides flexibility to respond to emergent circumstances or unforeseen risk. Clause 13 requires the Commissioner of Police and the CDS, with the approval of the NSC, the National Security Council, to establish a method for identifying each member of the joint force operating within a zone. Part 4 contains clauses 14 to 24 and provides the powers of a joint force in a zone. 14 empowers the Joint Command and senior security officials to control movement within a declared zone through cordons and the imposition of curfews. Once established, a notice must be published and displayed in conspicuous locations to inform residents and those seeking entry that they are going into a zone. The notice would state, for example, the hours during which persons must remain in premises, the hours of the curfew, the boundaries of a cordon, etc. Breach of the notice would be a summary offense. Members of the joint force enforcing cordons or curfews will have the powers of a constable. Clause 14 ensures the security forces can control access and movement in zones to maintain public order, while providing formal notice, enforcement powers, and penalties for non-compliance. Clause 15 provides that the duration of cordons would be no longer than 24 hours and a curfew no more than 72 hours. Clause 16 empowers members of the joint force to conduct searches of places, vehicles, or persons within a zone without a warrant, provided there is reasonable suspicion that an offense is being, has been, or is about to be committed. The member in charge of search must, as far as reasonably possible, ensure the presence of the owner, occupier, or person in possession, or their agent during the search. Further, those persons present should be allowed to observe the search. It should be noted that female persons must be searched by female officers. Officers may seize vehicles, articles, or documents that could prevent or control public disorder or aid in criminal investigations. This clause provides for specified items to be protected from seizure, including tools of trade or business and materials subject to legal professional privilege. A list of all seized items must be compiled, and as a consequence, receipts must be given to the owner, person in possession, or their agent as soon as possible. This clause balances the need for effective law enforcement in zones with procedural safeguards to protect property rights, legal privileges, and transparency. Clause 17 governs the custody, storage, disposal, and return of vehicles, articles, or documents seized under Clause 16. Under Clause 17, seized items must be secured in a location approved by an officer designated by the Joint Command while investigations, examinations, or legal proceedings are ongoing. Perishable items may be disposed of in a manner approved by the designated officer. In circumstances where a designated officer believes a seized item is no longer needed for controlling public disorder or as evidence, it must be returned to the owner, possessor, or their agent with a receipt signed. This clause ensures accountability, proper handling, and a legal mechanism for the return of seized property. Clause 18 provides the procedures and safeguards for arresting or detaining individuals within a zone and sets out grounds for arrest or detention, together with standard criminal procedures which will be applicable when an arrest is made. The arrested person must be brought promptly before a magistrate, who will determine whether the arrest or detention is justified. It is different from a state of emergency. There is no emergency tribunal. The ordinary processes of the law kick in on arrest. Where a magistrate determines that detention is necessary in the interest of justice, the magistrate may A, remand the person in custody for up to 48 hours, or B, require that after 48 hours, the person be brought before a high court judge for further proceedings. The person must be taken to a prison or police station immediately with the event recorded in the station diary. If the magistrate is not satisfied that detention is justified, the person must be released immediately. The power of arrest and detention also extends to persons fleeing the zone, because such persons would be treated as if they were still operating within the zone at the time of arrest. This clause ensures that arrests and detentions in a zone are based on reasonable grounds, subject to judicial oversight, and documented for accountability. Clause 19 seeks to create summary offenses against the joint command or joint force, such as to threaten, assault, obstruct, or hinder any member of the command or force or anyone in performing duties under the Act. Clause 20 establishes oversight and safeguards for individuals held in custody, where a person has been in custody for 36 hours without a magistrate's order. The officer in charge must inform a senior officer not below the rank of assistant superintendent and must record this fact in the station diary. The senior officer must investigate the circumstances and ensure the person is immediately brought before a magistrate. This ensures timely judicial oversight for anyone detained beyond 36 hours. Clause 21 sets out the rights and protections for individuals arrested or detained in a zone. For example, all complaints by or concerning a detained person must be recorded in the station diary. A detainee may receive visits as permitted by the prescribed officer. A detainee is entitled to receive food, clothing, and other items necessary for health and welfare and medical attention. Clause 21 emphasizes accountability, respect for human rights, and access to essential support for detained individuals. Clause 22 provides for the use of body-worn cameras by the joint force during operations in zones. Under this clause, protocols and procedures to govern the use of body-worn cameras may be developed to cover A, when cameras can be used, B, who can access the recorded data and under what circumstances, C, how the data may be used, D, rules for activating or deactivating cameras, E, instances where members must inform the public about the recording, and F, documentation of time and reason for deactivating cameras. This clause ensures accountability, transparency, and the regulated use of recording devices during operations in zones. Clause 23 provides for the registration of weapons assigned to members of the joint force to be registered with the Trinidad and Tobago Forensic Science Center before operations in a zone, unless the Chief of Defense Staff or Commissioner of Police decide otherwise. This clause will promote accountability and traceability of weapons used in operations. Clause 24, which is the last clause in Part 4, provides that joint force members may require anyone in a zone whose identity is unknown to provide their full name and address if there are reasonable grounds to suspect the person's involvement in an offense or to aid in the investigation of an offense. It is a summary offense to fail to comply with such a request unless the person has a reasonable excuse. This clause ensures that the joint force can verify identities to support law enforcement and investigations within a zone. Part 5 is the last part of the legislation. It contains clauses 25 through 28. Those clauses establish the Social Transformation Committee. Clause 25 provides that the Prime Minister must establish a Social Transformation Committee within 5 working days after a zone is declared. Further, the rules governing the committee are set out in the schedule to the bill. 26 sets out the functions of the committee, such as to assess conditions in the zone, identify threats to sustainable development, create a comprehensive development plan covering areas such as health, environment, social and infrastructural improvement, education, and economic development. The committee is required to pay particular attention to vulnerable persons in the zone. Clauses 27 and 28 are the general provisions. 27 confers a regulatory making power to the minister responsible for national security. In our case, that will be the minister who has portfolio responsibility for Homeland Security. Clause 28 provides for parliamentary review and oversight of the Act. There's a schedule to the legislation. The schedule sets out the constitution of the Social Transformation Committee. It also outlines the process of appointment of members of the committee, including the chair and deputy chair, and establishes procedural rules in relation to the internal operations, management, and meetings of the committee. Now, I am well aware that this legislation is groundbreaking legislation in Trinidad and Tobago. As I say, it is legislation that has been attempted with resounding success on the ground in Jamaica. My colleague, the Minister of Homeland Security, will give some statistics which reveal that homicides have essentially dropped off the cliff. Woundings, serious woundings, and violent crime have dropped off the cliff in Jamaica. There are constitutional issues, and I wish to turn to that now. The government is well aware of the impact this bill has on our constitutional rights and freedoms. This is evident by our insertion into the bill of the constitutional preamble, the clause expressing the bill's inconsistency with the Constitution and the parliamentary certificate. But it is a well-established principle that our Constitution is interpreted following a broad and purposive approach. There are several cases. In A.G. and Whiteman, 1991, the Privy Council said that the language of our Constitution falls to be construed not in a narrow and legalistic way, but broadly, so as to give effect to its spirit, and this is particularly true of those provisions which are concerned with the protection of human rights. In Suraj and the Attorney General, the Privy Council held that constitutional rights have all an inherent limitation, and such limitation can be exercised where the public interest so requires. We think that the public interest requires a limitation on the traditional rights, given the realities which face us in this country. Importantly, Mr. Speaker, in Suraj, by a unanimous decision, the Privy Council reasoned that the fundamental rights, including the right to life, the right to free movement, and the like, can be infringed by ordinary or subsidiary legislation without the requirement of a special majority vote, once the legislation satisfies a proportionality test. This judgment further bolsters the earlier decision of the Privy Council in Surat and the Attorney General, in which Baroness Hale famously said that it cannot be the case that every act of Parliament which impinges in any way upon the rights protected in sections 4 and 5, of which these are rights protected in 4 and 5 of the Constitution, is for that reason alone unconstitutional. Legislation frequently affects rights such as freedom of thought and expression and the enjoyment of property. These are qualified rights which may be limited either by general legislation or, in the particular case, provided that the limitation pursues a legitimate aim and is proportionate to it. And then she says these words: it is for Parliament in the first instance to strike the balance between individual rights and the general interest. We think that it is a matter for this Parliament to strike the rights between the individuals to live in a manner which is free from gang warfare, which threatens to envelop all of us, and the rights protected by sections 4 and 5. Now, there is a case in the local court of appeal, Naidiki versus Attorney General of Trinidad and Tobago, which concerns the unlawful detention and deprivation of liberty without due process. Now, in his judgment, Mr. Justice of Appeal Jamada, as he then was, he's now in the Caribbean Court of Justice, said these words. He said, "In my opinion, the liberty of the person, which is really their freedom, is one of the most essential of the fundamental rights. It is therefore no accident that protection of liberty is the first right that is recognized and declared under Section 4A of the Constitution. Deprivation of liberty without due process is therefore one of the most serious of constitutional violations." The court emphasized that any detention of a person must be reasonable, proportionate, and subject to judicial oversight, and that any arbitrary or indefinite detention will be in breach of Section 4A of the Constitution. And then he went on to say that for the reasons stated above, I say that an arrest or detention under this bill will be reasonable, proportionate, and subject to judicial oversight. And that is him saying that on me. Saying that. The point that I wish to make is that we have sought to subject all of the powers which we have granted to the police and army in this new dispensation to judicial oversight. There are limits on the amount of time that they can hold a prisoner for. When they hold a prisoner, they must carry that prisoner to a magistrate, and thereafter to a judge. We say that those...
Honorable Attorney General, you have 4 more minutes, okay?
Sure. We say that those are proportionate measures and that they are justifiable in a society that has a proper respect for the rule of law, when faced in particular with the nature of the threat that we face. The government acknowledges, Madam President, that the bill breaches the freedom of movement guaranteed under 4(9) of the Constitution, and clause 14 of the Constitution clause 14 of the bill empowers a joint command to establish a cordon around or in a zone that is a breach of the Section 4(9) right. But we say that that is proportionate and an appropriate measure to treat with the difficulties which we now face as a society. At its core, this bill is committed to safeguarding the right to life of every citizen. In doing so, the bill seeks to reinforce the authority of the state in all communities and to prevent criminals from regaining the influence which they had a short year and some ago. Therefore, the purpose of the bill is to restore public order through enhanced security measures while simultaneously addressing the root causes of crime through community development. Madam President, the proliferation of crime in Trinidad and Tobago in the past, and in the past decade in particular, demand immediate legislative intervention to adequately address and combat the flagrant acts committed by offenders against law-abiding citizens. There is no singular approach to this problem which we face as a society. In order to effectively and expeditiously deal with this multi-layered and complex issue, the government introduces this piece of legislation as one of the tools to deal with the issues that give rise to serious crime in our communities. The bill is not intended to be a quick, conventional, or reactive measure to crime. It is a comprehensive tool that enables a coordinated strategy aimed at reducing crime while protecting lives. The government took office with a number one priority. That priority was to protect the lives of our citizens. We say that this bill is a measure that does that. It is designed to protect and to enhance the quality of life in our most vulnerable communities. Its purpose is not to stigmatize these areas, but to strengthen engagement, to build confidence between citizens and the state. Beyond the benefits to communities, this legislative initiative is envisioned to also contribute to the improvement of procedures and protocols within the security forces. All law-abiding citizens are encouraged to support the security forces, to embrace this initiative, and to embrace their roles as stakeholders in the new dawn which we see in this country. Madam Deputy Speaker, with these words, I beg to move.
Thank you, Honorable Attorney General.